Okay, thank you. Okay, we're going to get started. Hi, everybody. Thank you so much for coming to Langfan. My name is Bretta Melkin. I am one of the competitions editor for the Moot Court Honor Society, and I want to welcome you to the final round. This is an annual competition that Moot Court hosts for Cardozo students, so we're very excited to hear what you all have to say. Before we get started, I just would really like to thank our final round judges, Professors Reinert, Roth, and Higgins, who've graciously agreed to be here tonight. And I'd also like to thank, oh yeah, let's give them a round of applause, for sure. Thank you. I would also like to thank Carl Hervich, who is filling in for me next year in this position, who helped me a great deal in the planning of this competition and tonight, because I was in class during the preliminary rounds. And I'd like to, let's give him applause. Sorry, I keep forgetting that. And I'd like to thank my current board and next year's board for just kind of putting this together for what it seems to have been a great competition so far. And without any further ado, we'll have our finalists. So first up, you have the stage.
In the recent cases of District of Columbia versus Heller and McDonald versus Chicago, the U.S. Supreme Court finally recognized that the Second Amendment to the U.S. Constitution protects an individual right to bear arms for self-defense. However, the court restricted its holdings in those cases to the right to use firearms at home. Predictably, there has since ensued a cascade of legal challenges to various other gun regulations across the nation. The ones that we are here to analyze this evening, namely laws that forbid domestic violence misdemeanor convicts from owning guns, ultimately pass constitutional muster. Such laws, you see, strike a legitimate balance between the government's duty to protect the people and the people's rights to protect themselves. To begin, the question presented to us today is essentially correct in presupposing that the Second Amendment does in fact protect an individual right to bear arms. Now, the most popular opposing viewpoint holds that the amendment is actually meant to protect state governments' prerogatives to form government militias without federal interference. If I may be so bold, this humble 3L begs to differ. The Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed." It makes no facial mention whatsoever of the states. Now, this is significant for two reasons. First, everywhere else the Constitution mentions the states or their powers or prerogatives as against the federal government, it refers to them as states, not as people. The clearest example of this is the 10th Amendment, which actually draws a certain contrast between the states and the people. It reserves the powers not delegated to the states by the Constitution to the states respectively or to the people. Second, every other part of the Bill of Rights that refers to the people is universally viewed as protecting an individual right. For example, the First, Fourth, and Ninth Amendments all refer to the people as the holders of certain rights. Now I ask you, does the Ninth Amendment hint at unenumerated states' rights? Does the First Amendment really protect the state government's right to assemble peacefully or to petition the government for a redress of grievances? Does the Fourth Amendment really shield the state governments from unreasonable searches and seizures? Is that really the purpose of the Fourth Amendment, to prevent Barack Obama from stopping and frisking Chris Christie? Take a moment to visualize that, you please, and color me skeptical. Ladies and gentlemen, it hardly stands to reason that the framers would have used the word people to refer to the states in the Second Amendment, while using that same word, people, to refer to private citizens everywhere else in the Constitution. What then are we to make of the Second Amendment's prefatory clause, which, as we all know, describes a well-regulated militia as being necessary to the security of a free state? Well, when the United States Senate Consider the draft amendment in September 1789. It specifically rejected a proposal to include the words "for the common defense" immediately after the words to keep and bear arms. In other words, the framers considered and rejected the notion that the Second Amendment should serve a national security purpose rather than a self-defense purpose. Even Harvard Law School liberal luminary, Professor Lawrence Tribe, has admitted that no known writing surviving from the period between 1787 and 1791 states that the Second Amendment protects a collective or government power, be it of the states or the federal government, rather than an individual right. With all of that said, however, it must never be overlooked that the rights enshrined in this nation's basic law generally have limits. For example, the Free Exercise Clause of the First Amendment does not protect deviant and dangerous religious practices such as polygamy or human sacrifice. The Free Speech Clause of the First Amendment does not protect false statements of fact or threats or incitement of imminent lawless action. The 15th Amendment specifically refers to American citizens' rights to vote, yet many states deny that right routinely, current and even former convicts. Now, such limitations to fundamental rights often arise in areas where the exercise of those freedoms by individuals poses a significant risk of substantial harm to other people. The Second Amendment right to armed self-defense is especially vulnerable to just such a limitation by very nature. After all, firearms are weapons. These are instruments that are designed to inflict injury or even death on human beings, and other living things for that matter. Therefore, modest gun control regulations are likely to survive even the strictest level of constitutional scrutiny. After all, protecting innocent people from injury or even death is not only a compelling government interest, it is the ultimate government interest. So, are laws that disarm domestic assailants narrowly tailored enough toward that compelling government objective? I dare say they are. In the 2010 case of United States versus Scoyen, the Seventh Circuit Court of Appeals rightly upheld the federal domestic violent offender gun ban against the Second Amendment challenge. Relying on extensive statistical evidence, the Court of Appeals found that domestic violence misdemeanors are often every bit as serious and as grave as felonies. What's more, also based on extensive evidence, domestic violence offenders tend to have a high propensity to reoffend. Survey research establishes or estimates their recidivism rate at between 40 and 80%. Most critically, firearms are far and away the most frequently used weapons in domestic assault. All of these factors and more establish a more than sufficient nexus between the challenged laws that we're examining today and the compelling government interest that those laws are intended to serve. I should make it clear at this point that I in no way mean to denigrate the right to bear arms. Individuals have the right to fight back against violent attackers to protect their own safety and, in many cases, their very survival. I would submit to you that in the dangerous world that we inhabit, and I know this is a controversial position, there are few more fundamental rights that a person can exercise than the right of self-preservation. As a practical matter, law enforcement is all too often unable and sometimes even unwilling to arrive on the scene in time to save the day. As a matter of principle, free men and women should not have to entrust their very survival and security to the state. Nonetheless, ultimately, it is law-abiding citizens' right to self-defense that most strongly and clearly outweighs the government's legitimate public safety interest. Consider the rhetoric that we continually hear in the debate over guns in America. Defenders of the right to bear arms, Second Amendment absolutists, if you will, continually argue that gun control simply takes firearms out of the hands of honest people and inadvertently leaves them in the hands of those who would prey on those innocents. In this case, however, we are appraising a law that specifically targets those who have been proven to commit violent crimes and who are statistically confirmed to have a high likelihood of reoffending in the future. Ladies and gentlemen, this kind of law is not inimical to the fundamental right of self-defense that underpins the Second Amendment. If anything, it complements that right. The whole premise from which both propositions flow is that honest, innocent, law-abiding people deserve to have a fighting chance. All that laws like these do is give them better odds of defending themselves successfully against their predators. Ultimately, then, laws that disarm domestic assailants, if you will, simply send a perfectly legitimate message to the American people. They say to them, you may take up arms in self-defense. What you may not do is take up those same arms to violate the rights and the safety of other people, of innocent people. That is not too much to ask. It is not too much to ask for the Constitution, and it is certainly not too much to ask for the citizens of a society that, after all, is based on the bedrock principle of ordered liberty. Thank you very much.
I'm 122. Good evening. In contemplating today's question, which is as to whether or not a misdemeanor domestic violence conviction should bar a person's Second Amendment right to bear arms, I came across a quote from famed attorney Alan Dershowitz. Foolish liberals who are trying to read the Second Amendment out of the Constitution by claiming it's not an individual right or that it's too much of a public safety hazard don't see the danger in the big picture. They're courting disaster by encouraging others to use the same means to eliminate portions of the Constitution they don't like. So, keeping this in mind, I'm thinking about Vice President of the National Rifle Association, Wayne LaPierre's statement that the National Rifle Association is the largest civil rights organization in the United States. I find this to be particularly distasteful, especially in the political climate that we're in right now and with the epidemic of gun violence in our country. But I feel that banning statements like this would be a violation of the First Amendment. This seems pretty clear. The Second Amendment grants us an individual right to keep and bear arms. And these arguments were made in the District of Columbia versus Heller when Justice Scalia pointed out in exhaustive detail the difference between the prefatory clause and the operative clause. He asserts ultimately that the prefatory clause doesn't limit or expand the scope of the right to bear arms. This makes sense because hypothetically, if we were concerned about regulating a militia on our day-to-day basis, we would be more likely to ban handguns as opposed to submachine guns, and we all know that that's not the case. This is also an issue that would be better handled from state law, not federal law. The idea that you can be convicted of a misdemeanor on the state level or at the federal level and then have it characterized at the federal level as a violent felony is confusing for local law enforcement and difficult to enforce ultimately. For example, some states don't have domestic violence statutes. Some states have misdemeanor domestic violence statutes that aren't included in the federal definition of a misdemeanor domestic violence statute. And other states, it matches up pretty well, but we don't want to leave it up to the federal government to enforce something that at the local level could be much better handled by state police officers. So for people who are victims of domestic violence, it's important that they can depend on the local police force to actually disarm disarm assailants. And they can do this, and they're better equipped to do this, again, at the local level. So ultimately, the effectiveness of the law which seeks to ban misdemeanor domestic violence convicts from having weapons, is better enforced at the local level, and ultimately, this would be the most successful way to protect victims of domestic violence and victims of assault generally. Thank you.
Hello, I'm 123. In the United States, we are guaranteed a number of rights: the right to privacy, the right to be free from unreasonable searches and seizures, the right to free speech, and the right to bear arms. But just because we're guaranteed these rights does not mean, and is never meant, that they are unlimited. Today we've been asked to address whether barring a person convicted of a misdemeanor domestic violence crime from being able to possess a firearm is constitutional. And the answer that the federal courts have provided us time and time again is yes. This very question was addressed and answered by the 11th Circuit 3 years ago in United States versus White. And in that case, the court held that a person who was convicted of a misdemeanor domestic violence crime could have their Second Amendment right to bear arms prohibited. And the court based that determination on it by reasoning that that prohibition falls into the prohibitions that have been deemed by the Supreme Court to be presumptively constitutional because of the risks that they pose to the public. Specifically, in the District of Columbia versus Heller, the United States Supreme Court held that there are certain prohibitions on the right to carry a firearm that are necessary in order to ensure the public safety. Some of the examples they provided were restricting felons or the mentally ill from having a firearm, or being able to use or carry a firearm in sensitive locations, such as schools or government buildings. And within the past 5 years, 2 circuit courts and several district courts have recognized yet another prohibition that must necessarily fall into those presumptively constitutional. And that is the prohibition on those convicted of misdemeanor domestic violent crimes from carrying a firearm. Now, while opponents to such a prohibition might try to claim that simply being convicted of a misdemeanor shouldn't be enough to be stripped of your Second Amendment right to bear arms. However, that reasoning fails for several reasons. First, what is important to remember here is that we're not trying to restrict the average law-abiding citizen from being able to have a firearm and protect themselves and their families. What we're trying to do is prohibit those already convicted of violent domestic crime, not those just having accusations brought against them or those involved in non-violent domestic disputes. We're talking about prohibiting those already found guilty of a violent crime. And not just any violent crime, a violent crime against their own relatives. Additionally, it has been shown that firearms used in domestic disputes are deadly. In a study done in 2009 by the FBI, they determined that a victim is 12 times more likely to die from a domestic dispute if a firearm was found in the home. Additionally, police officers, 8% of their fatalities have resulted from them responding to domestic disputes involving firearms. Additionally, data has also shown that persons convicted of domestic violence have a high recidivism rate, and that they are 3 times more likely within the first year of their conviction to engage in domestic violence again. As a result, it is vital that we keep one of the most lethal weapons out of these offenders' hands in order to ensure the safety of their own relatives. And lastly, in Heller, the Supreme Court specifically held that one of the recognized prohibitions that are presumptively constitutional are those restricting felons from carrying firearms. Now, why that is important is because not all felonies involve violence or are likely to lead to a violent felony involving a firearm. Instead, what this specific prohibition involves is all violent misdemeanors. So while all felons are restricted, despite the fact they might not have engaged in a violent felony, here the only misdemeanors that are being restricted by this prohibition are those that have actually been shown to involve violence. What we have before us is not a prohibition to restrict law-abiding citizens' right to carry a firearm. What we have is a prohibition meant to quell a rampant and troubling problem rising in the United States, that of domestic violence. Given this objective and the real danger that these offenders having firearms can pose, it is clear that this prohibition falls squarely within the presumptively constitutional prohibitions recognized by the United States Supreme Court and is a constitutional bar on such offenders' Second Amendment rights. Thank you.
Contestant number 121. Good evening. Every year, an estimated 2 million women are victims of domestic violence. Of the 2 million, approximately 6,000 women die every year. And of those 6,000, 70% are killed by a gunshot wound at the hands of their abusers. Statistically, everyone in this room has been affected by domestic violence in one way or another. Domestic violence is so prevalent, in fact, that you probably all know someone who has been a victim of domestic violence, or you may have even witnessed it yourself at some point in your life. And in fact, it is quite likely that some of us in this room have been victims of domestic violence ourselves. Stop and think about those situations, your own personal exposure to domestic violence. Should those people, the abusers in those situations, the ones that you have known, are these the kinds of people that you would want to own a gun? I don't think so. And we know that most domestic violence is not even reported. And of the cases that are reported, many do not lead to a conviction. Those that do rarely lead to anything beyond a misdemeanor domestic violence conviction. Now think, should those people be allowed to own deadly weapons? I don't think so. And apparently Congress doesn't either. Because in 1996, Congress answered that question in the negative when it passed the Lautenberg Amendment to the Gun Control Act. Among those who voted for the Lautenberg Act, some of the most pro-gun, pro-Second Amendment rights politicians in the nation. In fact, in the Senate, 97 voted yes, and only 2 voted no. They all agreed to this. And let me tell you why they agreed to it. Because after spending days thinking about domestic violence, the state of domestic violence in our country, and based on overwhelming evidence establishing that a gun is the key ingredient most likely to turn a domestic violence incident into a homicide, they decided to put a stop to this. And if this law makes a difference for just one person, it will have done its job. This isn't about guns, and it's not about the Second Amendment either. As my colleagues have said, the Lautenberg Amendment and other restrictions on the Second Amendment, particularly in the context of violent offenders, have been consistently upheld in the courts. This is merely a matter of public policy. And it's about not arming persons who have proved that they have neither the self-control, rational decision-making ability, or psychological stability to possess a deadly weapon without imposing a substantial threat to society. Being from the South, I myself have nothing against the Second Amendment right to bear arms, particularly as it protects an individual's ability to provide for their own self-defense, as it does for many women where I come from, and where it protects a person's right to go hunting for deer, duck, turkey, or hell, even to shoot beer cans once in a while for sport. I don't have a problem with the Second Amendment. But that freedom, that right, it ends as soon as an individual shows that he or she cannot be trusted with such a powerful and deadly weapon. It ends. The Second Amendment right comes with a responsibility, like all rights. And when you
commit a violent offense against someone, the question is not whether the offense is a felony or a misdemeanor. The question is whether or not you have a capacity towards violence to hurt other people. Let me say again, I have nothing against the Second Amendment right to bear arms. And in fact, at least once a year, I go hunting in the woods with my family. We go to a part of the Ozark Mountains in Arkansas that is open to the public. It's a beautiful and exciting experience. Out in the woods, where hunting is open to the public, you're always engaged in a special sort of social contract with all of the other hunters. Everyone wears specific gear and follows a particular protocol to prevent people from harming one another. It is a great sign of Americans' camaraderie and mutual respect for one another that a big group of us can carry our guns into the woods, shooting at game and even competing for game, yet respecting each other's space and observing community safety rules. Here's the thing about that, though. I really don't want to share those woods with someone who is an armed, violent offender. I don't trust that someone who has shown such a lapse in judgment, someone who has demonstrated such violent tendencies towards their own loved ones, will exercise the appropriate level of caution and self-control when armed in the woods. Allowing such people to possess firearms threatens domestic violence victims, for sure. But it also causes widespread insecurity throughout society. I myself feel personally threatened by the thought of a convicted abuser owning a gun in my neighborhood, in the woods, pretty much anywhere. A person who has been convicted of domestic violence at any level of degree or severity cannot be trusted with a deadly weapon. They have lost the privilege. They have a violent record, and they are individuals who should not have a gun. Thank you.
Good evening, everyone. 104. April 16th, 2007, Blacksburg, Virginia, and the campus of Virginia Tech University. 32 people dead. July 20, 2012, Aurora, Colorado, at a multiplex movie theater. 12 dead. And December 14th, 2012, in Newtown, Connecticut, at an elementary school in the heart of an idyllic, community-rooted town. 26 dead. These incidents, these tragic incidents, and the despicable many just like them, have provided the sights, the sounds, and the background for the gun control debate in the United States in recent years. But today I would like to frame the debate differently. Yesterday, if statistics held, 2 women were killed. Today, another 2 women will be killed. And tomorrow, 2 women and 1 man. All of them at the hands of their significant other, all of them with the use of firearms. That means, all told, almost 800 people will die this year because their intimate other picked up a gun and ended their life. And if you don't think that's a problem, let these numbers sink in. It would take 31 Newtown massacres, 67 Aurora movie shootings, or 25 Virginia Tech campus shootings to match the annual death toll in the United States from domestic violence murders with the use of a firearm. The question before us today asks if a misdemeanor domestic violence conviction should be able to bar a person's Second Amendment right to possess firearms for self-defense. And the answer is unequivocally yes. Why? Because it works to deter murder and incidents of domestic violence. But before we can discuss the effectiveness of such laws, we must ask a more fundamental question than should these laws be in place. We must ask, can they be in place? Laws have been promulgated making it unlawful for any person convicted of a misdemeanor domestic violence charge from possessing, transporting, or receiving a firearm at both the state and federal level, and that's just as well. States are, of course, entrusted with the police power to regulate the daily activities of their citizens. And time again, the Supreme Court has upheld the Commerce Clause power of Congress to regulate commerce within the several states. Now, in United States v. Lopez, the Supreme Court did strike down Congress's Commerce Clause power when it came to regulating guns in schools. However, the laws before us for review involve standard issue elements of interstate commerce: the purchasing, the shipping, and the receiving of firearms, and that puts the laws in question squarely in the purview of Congress's Commerce Clause power. However, the laws have come under attack from several areas, chiefly that the federal version of the law, commonly known as the Lautenberg Amendment, has created uneven enforcement on several levels and violates the Equal Protection Clause. First, it's argued that uneven enforcement comes by way of many states that do not define or do not punish for domestic violence and simply categorize them under broader categories such as assault or battery. However, in the United States v. Hayes, in a testament to the judicial system's conviction with regards to these laws, the Supreme Court simply fixed the glitch. The court stated that so long as any special relationship could be gleaned in the state conviction, the federal law would take effect. And this is good sense interpretation, because the law is now clear. If you assault a significant other, if you batter a significant other, if you abuse a significant other, whatever the state calls the crime is irrelevant. Your right to bear arms is no more. Unevenness, it has been argued, is also derived from the lack of a public interest exemption. This is to say, police officers and members of the military will also lose their right to bear arms for misdemeanor domestic violence convictions, even if they would not lose their right for some felonies. This argument is classic red herring. Military police force have long shown a proclivity for staying away from hiring those with domestic violence convictions as is, and the courts have regularly noted as much when faced with that challenge. Fact is, no challenge to these laws, constitutional or otherwise, have ever been upheld. And so, the courts have been crystal clear in pronouncing that a law can ban a person's Second Amendment right to possess firearms in light of a domestic violence misdemeanor conviction. Of course, if we listened every time the Supreme Court spoke on an issue, we might live in a world where a woman couldn't work in the medical field, folks of African descent weren't afforded the same constitutional rights as folks born here, and a Major League Baseball player couldn't even file for free agency in order to bog his team down with a $300 million contract. So the question before us today asks not whether the law can bar someone convicted on a misdemeanor domestic violence charge or Second Amendment right to bear arms. It asks, should it? And that is not as much a legal question as it is a question of societal ideals and a question of the law's effectiveness. When Congress amended 18 U.S.C. 922 in 1996 to include provision G9, making it unlawful for any person convicted of a misdemeanor domestic violence crime from possessing, transporting, or receiving a firearm, it did so with deterrence in mind. To that end, Senator Frank Lautenberg, the sponsor of the bill, stated at the time of its passage that anyone who attempts or threatens violence against a loved one has demonstrated that he or she poses an unacceptable risk. And so the goal of the law has been clear: deter death. And the law has deterred. The numbers are still grim, to be sure. I read them before. But from 1996 through 2006, the Lautenberg Amendment blocked 150,000 purchases of guns by those convicted of domestic violence offenses. Detractors of the law will surely note that domestic violence is sadly on the rise, and repeat offenses in some states have risen to as high as 60%. Undoubtedly, lawmakers must still rise up and punish those who commit such heinous crimes, whether a firearm is involved or not. However, the Lautenberg Amendment and the state laws just like it had one simple goal: no one else has to die in instances of domestic abuse. And as of 2006, 150,000 people to 60% of whom may have been repeat domestic violence offenders had their right to bear arms denied. It should come as no shock that in 2006, when Duke University did a study on the effects of the law, they found an 8% decrease in domestic homicides. The law is working. Folks may debate about the right to bear arms as a fundamental American institution, but there's no right more fundamental than the right to live. These laws are not about restricting the former so much as they are about protecting the latter. Protecting our rights to live, not figuratively, but quite literally. And so long as the laws are protecting that most basic right, the laws are here to stay. Thank you.
Line 107. There are stories of Lisa and Sarah and Robert, of John and Jane Doe. You've heard them before. They didn't wake up that morning thinking they were going to die. She had lived for years in fear of what he would do to her next. But I'm not here to tell you their stories. And I'm not here to get them your sympathy. They don't need your sympathy. They need your action. You asked whether a domestic violence misdemeanor conviction should bar a person's Second Amendment right to possess firearms for self-defense. The answer is yes. But our community has found this alone is not enough. The Bureau of Justice cites that approximately 1 in 3 female homicide victims and 1 in 20 male homicide victims are killed by a current or former partner each year. About 60% of these homicides are committed using a firearm. The New York Times has found that since 1995, in New York State alone, more than 300 felons and people convicted of misdemeanor domestic violence charges have regained their gun rights. Of that number, more than 400 have subsequently committed new crimes. More than half of these crimes are felonies, including murder, assault, child rape, and drive-by shootings. In the wake of tragedy, this country has turned inward, igniting into a divided debate on our gun policy, including the role of guns in intimate partner violence. Many argue that citizens have the right to defend themselves. Denying anyone their Second Amendment right is an unjust burden. I concede that though the Constitution protects a citizen's right to defend themselves with firearms, this is not the issue we're addressing. This is not a burden on a law-abiding citizen. It's on a criminal who, by harming another, has lost the trust of our society in their ability to exercise this right appropriately. Congress agrees. In 1996, Congress added Section 922 G9 to the Gun Control Act of 1968, prohibiting anyone previously convicted of a misdemeanor crime of domestic violence from possessing any firearm or ammunition. Congressional record on that day shows that the bill passed with almost unanimous support and represents Congress's recognition that anyone who attempts or threatens violence against a loved one has demonstrated that he or she possesses an unacceptable risk and must be prohibited from possessing firearms. The legislature reasonably believes that such individuals may resort to violence again, and that in the event they do, access to firearms would increase the risk that they might do grave harm, particularly to those in their household who have fallen victim to their violent hand before. But in U.S. v. Lewitsky of the Seventh Circuit, Lewitsky appeals, contending this section is in violation of equal protection principles. Instead, the court found that there is legitimate legislative purpose, protecting our public, specifically those who have already become victims. Congress intended to protect against those who have already committed crimes, and the court upheld this intent. In U.S. v. Mills of the Fourth Circuit, Mills contends that this statute creates a presumption that he is incapable of reform. Rather, the court found that there are mechanisms for relief from this disability, through pardon and through an application to the Attorney General when deemed the time is right. There is no assumption on the part of the court, nor myself, that reform cannot occur. Rather, there is a necessary measure to ensure that our victims are protected from the catastrophic results of when guns end up in the wrong hands too soon. It is critical to continue to bar the right to possess firearms from those with domestic violence misdemeanor convictions. However, reality has proven this statute has fallen short of its goal. One concern is that inadequate or incomplete record keeping might prevent some of these individuals from being identified as prohibited persons, thereby enabling them from acquiring or possessing firearms without detection. Additionally, many domestic violence-related misdemeanors do not specifically state domestic violence in the statute, but rather are classified as general crimes against a family member or intimate partner. Though qualifying under the federal statute, this makes identification of the misdemeanor restriction inherently more difficult. Most importantly, though, there exists an implementation problem that must be tackled as we question how tragedy continues to happen in our communities. Less than half of all states have laws that actually authorize police to remove firearms when responding to domestic violence incidents. Even less have laws that authorize removal of firearms when issuing protective orders. Many states have neither. Despite this federal law, states continue to lack availability of enforcement mechanisms. Additionally, in his time as San Diego DA, Casey Gwynn found that there are very few proactive programs in place to get the guns from the offenders. Rather, it is necessary to rely on the offenders to come forward and surrender their weapons, a program that has been found to be unreliable. Today, we have been asked whether domestic violence misdemeanor conviction should bar a person's Second Amendment right to possess firearms for self-defense. 17 years ago, Congress answered that question. And though today I uphold their nearly unanimous decision, I must warn that we have found since that time, perhaps a statute is not enough. Thank you.
Competitor number 105. On October 14th, 1996, Derek Smith got into an argument with his wife. Now, this wasn't new to the Smiths. They fought all the time. And quite often, those fights ended in violence. In fact, Derek Smith had 4 misdemeanor domestic violence charges and convictions in just the past 3 years. But this night and this fight was different. Because on this night, Derek decided to pull out a gun, point at his wife, and pull the trigger. But before that bullet entered his wife's chest, it first passed through the body of their 6-week-old baby daughter. The baby daughter that his frightened wife had been holding and protecting in her arms throughout that entire argument. Now, I wish I could say that incidents like this are rare, but I can't, because it's just not true. The reality is that incidents like these happen every single year, every single month, every single week, and every single day. In fact, they happen 3 times a day. Every 8 hours, a woman in America will be murdered by her husband, fiance, or boyfriend. According to the FBI, between 2001 and 2012, more women were killed by their husbands and boyfriends than all the American casualties from September 11th, the U.S. war in Afghanistan, and the U.S. war in Iraq, combined. That's nearly 12,000 murders. And that's just domestic violence murders, and that's just women. What about men? 1 man will be killed every 2 days from domestic violence. And sadly, 1 child under the age of 13 will be killed every 6 days and will be killed by their own parents, step-parents, or guardians. The average age of those children, 7. That's 3 Sandy Hook massacres every single year. But if you really want to see how bad domestic violence is in America, look at the #1 cause of death among pregnant women. According to the CDC, between 2003 and 2007, the #1 cause of death among pregnant women is not complications from pregnancy, it's not car accidents, it's murder. And as shocking as those statistics are, they're not nearly as shocking as what you can do to your own family member and not be convicted of a felony. Take the example of Ferdinand Smith. Ferdinand Smith attacked his wife with a knife, and all he got for it was 10 years of pretrial probation for aggravated assault with a deadly weapon. And after those 10 years of probation were over, he had a completely spotless record. And when his wife finally decided to leave him after that probation was finished, he nearly strangled her to death for it. When she called the police, they didn't show up. And when they finally decided to arrest him 20 days later, it was too late. He'd already tracked her down and shot her multiple times in the face and chest. And the gun that he shot her with was his work gun from where he worked as an armed security guard at a children's elementary school. And while that story can teach us many lessons, one important one, especially in a time where 90 to 95% of all of our cases are plea bargained down, is that effective responses to domestic violence cannot be predicated simply on the fact that someone has to be convicted of a felony. The simple fact of the matter, a fact that has been exhaustively researched by the Department of Justice, is that any incident of domestic violence makes it more likely that violence will happen again, and that as that violence will continue to escalate as it continues to happen. Well, I hate to call this good news, the Department of Justice also tells us that domestic violence murders are almost predicated by at least one non-fatal domestic violence assault. Which means that if we can catch domestic violence early, we can prevent it from happening again. We can prevent the escalation and prevent the murder. How do guns fit into this equation? Of those 12,000 murdered women I mentioned, 2/3 of them were murdered by guns. That means by this time today, 2 women will have already been murdered in intimate partner with a gun. So if we're serious about domestic violence and we really want results, we have to look at guns. Even if we don't want to, we have to. So does taking away the right to possess a gun actually work? You hear a lot of arguments that taking away a gun will just cause someone to grab a different weapon. That all we're doing is converting gun violence and gun murders into fist and club and knife murders. But the empirical evidence says otherwise. According to multiple studies using the FBI's data, when you take guns away from people that are convicted of domestic violence misdemeanors, you get an 8% drop in domestic violence murders. Not a drop in just gun murders, all murders. So without these laws, those 12,000 women that were murdered would have been 13,000. And what about non-fatal domestic violence? Do those laws have any effect on them? The Bureau of Justice Statistics says yes. Since the passing of the Lautenberg Amendment, there's been a 68% drop in non-fatal domestic violence assaults. So what are we arguing about? It can't seriously be the fact that a misdemeanor is not serious enough to take away someone's gun rights. We take guns away from people all the time for less. You can lose your gun if you simply have a restraining order against you. No felony conviction, no misdemeanor conviction, no conviction at all. You can lose your gun even if you've just been indicted on a felony. And it doesn't even have to be a violent felony. Right now, we are taking away guns from white-collar embezzlers while we are leaving them in the hands of actual convicts like Derek Smith. Removing guns after a genuine conviction of a domestic violence offense is not a shocking expanse of state power. It's a targeted, limited application of principles we all already agree on. In fact, it's something that should have been passed hand with the restraining order provision back in 1968 and not 1996. Now, the Supreme Court has told us that the right to own a gun is a qualified right. It's a right based on self-defense. But self-defense assumes something. It assumes that you're using the gun for defense, that you are using it to defend yourself and your family, not attacking them. You can't be entitled to a right to self-defense if you are the person that everyone is defending themselves against. At the end of the day, if protecting yourself and your family is the key reason why this country allows us to have guns, then protecting your family from you has got to be a valid reason to take them away. But if it isn't, then those statistics are never going to change. And all those stories about strangers are eventually going to become a story about someone you know, about one of your friends, your sisters, your daughters, and your granddaughters. Maybe a granddaughter who goes to an elementary school guarded by someone like Ferdinand Smith. And if we leave guns in the hands of people like him, people who are mentally unstable, criminally violent, willing to hurt their own family members, who have rage problems, control problems, and power issues, then it's not just Ferdinand Smith who has blood in his hands. It's all of us. Thank you.
Good evening. Contestant 117. In April of 2011, Deborah Wigg obtained a protective order against her husband, Robert. The 39-year-old accountant was in the process of divorcing her husband, and in her petition described a violent incident in which he grabbed her by her hair, threw her to the ground, ripped out a door, and threw it at her. In her petition, she also clearly stated that he owned a 9mm semi-automatic handgun. Mr. Wigg was arrested and charged with assault for that criminal incident, and Mrs. Wigg was allowed to obtain a protective order. Yet despite this, her husband was allowed to keep his handgun. In November 2011, approximately 11 at night, Mr. Wigg broke into Deborah's home as she frantically called her parents. He killed her with a single shot to the head. He then drove to his in-laws' home. It's assumed that he intended to kill them as well, but they had rushed to their daughter and were at that time standing over her body. Mr. Wigg shot himself in their front yard and was pronounced dead at the scene. Had Mr. Wigg's gun been taken from him, and had he been barred from future access to firearms, it is reasonable to assume that Deborah might not have died. In July 2008, Melissa Batten filed for a protective order against her husband, also named Robert. Her estranged and abusive husband had at one point held a loaded gun to her head and then placed it against his own head, threatening to commit suicide. She was able to obtain the protective order, and yet the gun was not taken away. A mutual friend of the couple intervened and convinced Robert to sell his gun. However, only a short time later, he had a change of heart and proceeded to buy 2 new handguns. He then went to her home, dragged her outside, and shot her 8 times in the chest in the parking lot in front of her home. He then shot and killed himself. Had Mr. Batten had his gun removed and been prevented from having access to future firearms, it is reasonable to assume that Melissa might not have died. These tragedies, and others like them, and there are far, far too many, lend a very heavy weight to the question presented before us. Should a misdemeanor domestic violence conviction be sufficient to remove a person's individual right to possess arms for self-defense under the Second Amendment? The statistics gathered from numerous studies give a clear indication of the significance of this question. As numerous of my colleagues have mentioned, according to federal statistics, intimate partner homicides account for nearly half of the women killed every year. And more than half of those women are murdered with a firearm. This question can be answered by first analyzing the general right granted under the Second Amendment, and then determining how broad that right extends. The Second Amendment of the U.S. Constitution states that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This statement was a key component of the analysis of the Supreme Court case, District of Columbia v. Heller. In Heller, the court struck down a total ban on handgun possession in the home as inconsistent with the right granted by the Second Amendment, because the court in Heller stated that the right granted by the Second Amendment was a right for law-abiding, responsible citizens to possess arms for self-defense even without service in a militia. This ruling was affirmed 2 years later in the case of McDonald v. City of Chicago, where the court further applied the rights of the Second Amendment to the states, and the court noted that the core aspect of the Second Amendment, the very fundamental aspect of it, was the basic right of self-defense, which in the court's words is a right deeply rooted in this nation's history and tradition. However, even as the court affirmed and reaffirmed the individual right to possess weapons for self-defense, it also stressed that this right is, in the court's words, not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. The court clearly indicated that regulations for firearms are well within the right of the law. In particular, the court identified a non-exhaustive list of firearms regulations that are presumptively lawful, such as the regulation banning felons and the mentally ill from obtaining guns. In both the Heller and McDonald decisions, the court stressed that they were not casting doubt on any of these regulations that were presumptively lawful, and they also stressed that future legislators were within the right to experiment with broader regulations. The rulings in both Heller and McDonald clearly indicate that the right to bear arms on an individual basis for self-defense is subject to reasonable regulation, such as the regulation barring felons and the seriously mentally ill from obtaining weapons. These members of society have been determined to lack the level of responsibility necessary to have access to such weapons, and they've also been determined to pose a real and serious threat if granted such access. It is clear, then, that if a legitimate basis exists under which an individual has been determined to pose a threat, is deemed unfit to have access to firearms, that the law is well within its right to provide such regulations and to ban such access. This then brings the analysis to violent misdemeanor convictions in general, and more specifically to misdemeanor domestic violence convictions. The National Center for Biotechnology Information cites a case study conducted in California. In 1991, California changed its laws to prevent those convicted of violent misdemeanors from purchasing a gun within 10 years of their conviction. Before that, a study conducted by the NCBI showed that gun buyers who had even one prior misdemeanor conviction were 5 times as likely as those with no criminal history to be arrested for gun-related crimes or violent crimes. The new law was attributed to be the sole cause for the precipitous and significant drop in these arrests. With regards to specifically misdemeanor domestic violence convictions, the Violence Policy Center conducted an analysis of female domestic homicide, instances in where a woman is murdered by either a spouse, an intimate acquaintance, or a close relative. This study showed that in incidences where prior domestic violence had occurred in a household, a woman was 14.6 times likely to be a victim of such a homicide. Allow me to repeat that number. When there is prior domestic violence, a woman is 14.6 times more likely to be a victim of such a murder. That number is more than just terrifying. That number absolutely boggles the mind. These studies show a clear correlation between instances of misdemeanor domestic violence and later bloodshed. On the basis of this alone, it is more than reasonable to say that a misdemeanor domestic violence conviction indicates a strong basis to state that the convicted individual lacks the responsibility required to have access to firearms, and that this individual poses a real and deadly threat if granted such access. This basis would meet the analysis of Heller and McDonald, and the law would be well within its right to bar such an individual from having access to firearms. Thank you.
Thank you, and congratulations to all 8 finalists on a great final round. Now, if the judges will join me in the lobby, and we'll return with the results of the final round. So just hang tight. Thank you.